Professor Roberta Quall, who is the Raymond P. Nairo Professor of Intellectual Property Law at DePaul University here in Chicago. Prior to teaching, Professor Quall practiced IP law at Sidley and Austin in Chicago, and previously also clerked for Judge Garth of the Court of Appeals for the Third Circuit. Professor Quall graduated from law school at University of Pennsylvania, and she did her undergrad at Brown University. She has written numerous articles and is the co-author of leading case books in both intellectual property and real property. I should add that she is an expert, a leading expert in the area of moral rights, and has written this fantastic book called The Soul of Creativity that I commend to everyone in the room who's interested in copyright law. So without further ado, Professor Quall.
Thank you very much, Professor Lee, and particularly thank you for inviting me to participate in this conference and specifically on this panel with such a wonderful group of people. My students at DePaul have certainly learned. Am I on? Okay. Better? Hear me now? Good? Can you hear me? A little better? Okay. I was just saying my students at DePaul have certainly benefited and learned from all the hard work that Professor Lee has put into the Golan case as he's come to DePaul to address my students. So this is a wonderful panel. I think that Registrar Maria Palente certainly needs no introduction after the last stimulating session. So I will go on to introduce the remaining two panelists in the interest of time. So moving further to the left is Stanley Pierre-Louis. Mr. Pierre-Louis is the Vice President and Associate General Counsel for Intellectual Property and Content at Viacom. And he's responsible in this regard for managing all of the IP litigation, including developing strategies for protecting digital content. Prior to this position, he actually served as the co-chair of the Entertainment and Media Law Group at Case Scholer. And before that, he had served as the Senior Vice President for Legal Affairs for the Recording Industry Association of America, where he really led several important copyright litigations, including the Grokster opinion. Our last panelist is Mr. Thomas Goldstein, who was the counsel for the petitioner in the Golan decision. Mr. Goldstein teaches Supreme Court litigation at Stanford and Harvard Law Schools and is the founder and publisher of the SCOTUS blog. The National Law Journal named Mr. Goldstein as one of the 40 most influential lawyers of the decade, and the Legal Times named him as one of the 90 greatest Washington lawyers of the last 30 years, transforming the practice of law before the Supreme Court. So I think we are in for quite a treat. The case that is going to be the focus of our discussion, of course, is Golan versus Holder. Just to take a minute or two and set the stage for the discussion. Can you hear me? Is it coming through? Okay. In 1989, the United States joined the Berne Convention, which is the principal international accord governing international copyright relations. 5 years later, Congress enacted specifically Section 514 of the Uruguay Round Agreements Act, the URAA, which essentially granted copyright protection to pre-existing works of Berne member countries that were protected in the country of origin, but were lacking protection in the United States for any number of particular reasons. So one consequence of this is that Section 514 restored American copyright protection to these certain foreign works that had fallen into the public domain of this country. So Golan was really all about the constitutionality of a section of a statute that restored copyright protection to what were, in effect, public domain works. Writing for the majority, Justice Ginsburg held that the URAA is constitutional. Specifically, the court concluded that really nothing makes the public domain in any and all cases a territory from which works may never exit. Justice Breyer, joined by Justice Alito, wrote in dissent that the URAA is unconstitutional because it doesn't advance a principal purpose of the Copyright Act, which is to elicit new production. All right, so with that framing in mind, I'd like to address a number of questions to our panelists, and we are going to reserve 10 minutes at the end for Q&A from the audience. All right, so the first question that I would like to address, and this would be principally to Mr. Goldstein, but to any of the panelists that want to respond. The majority decision in Golan relied on language which was also a part of the previous Supreme Court decision in Elder that looked at the Copyright Term Extension Act. Speaking of the traditional contours of copyright protection as being built-in safeguards for the First Amendment copyright balance. These safeguards being, of course, the idea-expression dichotomy and the fair use doctrine. I'd like to start by pushing back a little bit against this in light of the numerous academic commentary that exists really critiquing the First Amendment and critiquing the idea-expression dichotomy as vehicles that are able to really function in the way that the court suggested, because the doctrines are either too amorphous or difficult to apply. So I'd like to open the discussion by asking you to share your thoughts with respect to specifically those built-in safeguards and their efficacy in safeguarding this copyright First Amendment dichotomy.
Sure, and so let me just start by thanking the organizers for having me, and the usual caveat that what I have to say is on behalf of myself rather than the clients in the case. And also I should say that the real effort in the case, and it was a decades-long work, was done by IP folks at Stanford led by Tony Falzone, and so everything good that happened in the case, he gets the credit for, and everything bad I should rightly be blamed for. I am glad to be here on behalf of the Constitution in the case and all that is right and good, and talk about why we thought at the time that there were real problems with the statute. The question is obviously sort of a softball for our side of the case, and the idea is that the Supreme Court had thought, and Justice Ginsburg had said first in Eldred and then said again in Golan, that we don't really have to sweat concerns about exceeding the scope of the copyright power because there are doctrines, neutral doctrines, like fair use and the idea-expression dichotomy, that protect the real interests that are at stake in the Constitution. And we had said to the Supreme Court, look, when you said in Eldred that everything's going to be okay because there are these other doctrines, you weren't saying that these are the only doctrines. And to give the simplest example, no one could say that you could have a law under the copyright power that says only men can have copyrights, not women. There have to be other constitutional constraints on Congress's exercise of the copyright power. And we said that one of the big ones has to be the public domain. And that is, if you have something right now that you're relying on, that you're making derivative works out of, that you are expressing, that the Copyright Clause, which says that that Congress can assign copyrights for limited times, means that once that time is up, there has to be some teeth to that, and that the work then goes into the public domain where everyone can use it as the building block of ideas and expression and creativity and making new and wonderful things, or simply performing them or reading them or whatever. But if you instead were to treat that limited times restriction to mean that things can be copyrighted, then in the public domain, and then they can be copyrighted again, then particularly in the wake of Eldred, where the Supreme Court had said, yes, Congress can set a term for copyright of N number of years, but as you get to the end of that, they can add on 20 more, and then 20 more, and 20 more. Then you've really gotten to the point in which limited times doesn't mean anything at all. So we had said that there were this notion of the public domain was another important constraint, another important doctrine beyond just idea expression and fair use. And it turns out that we are completely wrong, because 7 justices or 6 justices of the Supreme Court said that we were, and that the court has decided that it is extraordinarily deferential. Sometimes in some provisions of the Constitution, it gives great deference to Congress. When other things are at stake, like the campaign finance laws, not so much. And this is an area in which the Supreme Court, for reasons that we'll get into in much greater detail, has decided that Congress is the best judge of where the limits of the copyright power are.
But didn't you actually lose 8-0 on that front as opposed to 6-2? And I say that because in Justice Breyer's dissent, he doesn't get into whether or not you get this vested right in a public domain work. He really looked to whether or not the progress of science was being upheld, whether a new work was being created. And I don't recall him really addressing the issue of whether you get this vested right in the public domain. Like, does that have legs anywhere?
I think so. I don't think that you heard me saying that we have a vested right in the sense that, there's absolutely nothing that can't be taken out of the public domain. We listed a bunch of statutes where Congress had done relatively minor things, but he's very concerned about the public domain in his dissent. I mean, I don't mean to overstate the importance of it. 2 justices of the Supreme Court is as worthwhile to me as, 12 cents. It doesn't, you don't get really anywhere with it, and you can't really take that to the bank. But I do think that the dissent was with us on the principle that it was highly anomalous for Congress to take a significant number of works out of the public domain.
So where does this leave us going forward? I mean, given this deferential stance that historically has been operative in the copyright area, does Congress essentially now have a blank check when it comes to enacting copyright laws? Are there any? So Registrar Palenti is saying no. So where are the breaks?
They don't have a blank check, but it's the right question, right? Going forward, is Congress? What people are upset about is that they would have liked the Supreme Court to be a check on the bad decisions of Congress or the perceived bad decisions of Congress, and the court basically said, they kind of said, no matter how dumb Congress is, sorry, we can only look at things narrowly, and unfortunately their bad decisions meet the constitutionality test. So what would be on the table? Well, Justice Ginsburg was pretty clear. She said if anything were to run afoul of the bedrock principles, the traditional contours, meaning the idea, expression, economy, or fair use, we'd be right here. And there are things, you said copyright law, not copyright act, so there are parts of Title 17 for which 107 does not apply. So, there's that. And so everything's not off the table, but yes, Congress has a lot of deference. So that leaves you with the legislative process. And, this is a very interesting case because it's taken so long. So we're talking about a law enacted 18 years ago, finally decided upon in 18 years later. In the 90s, there was a lot of activity about strengthening IP rights, strengthening copyright in particular, especially because it was a boost to our economy and trade was really, really important. And, people looking back say, well, why wasn't Congress standing up for the public domain in 1994? Or even when we first implemented Byrne. And I think the answer is they were, when we initially were implementing Byrne, taking a very minimalist perspective. So then if the gripe is in 1994, they shouldn't have caved in to trade pressure, I actually don't think that that's what happened. I think that we didn't comply with Byrne. USTR would have a heart attack if I were to say that out loud. But that is the view of the Copyright Office, that we did not fully comply with our Byrne. We didn't meet Byrne compliance when we first joined, and this was necessary as the price of entering Byrne. So now, are we just going to make one bad decision after another from a policy perspective, is Congress to be trusted? I think you can say, you know, with a long view of legislation, that today, if you look at trade or international discussions, there isn't one that doesn't include a discussion of exceptions and limitations for the public or public access. So whether it's ACTA or the Trans-Pacific Partnership that's being negotiated, everyone is focused on those things, and it would be the first set of questions from Congress as well. So it's not a perfect process, but the legislative process, you know, if you take a longer perspective, it has already shifted since these issues became ripe.
Sure.
Yeah, and I think sometimes in some of the decisions they will sort of hint that, look, you've gotten another 20, or you've done this act, and I seem to recall some language about, well, you know, of course, as you move forward, you'll give this some real deep thought before you come back to us with this.
Yeah.
And so there's almost an admonishment by the court that says, we get that we give you deference on this, but if you come back, it's going to smell a little fishy, so really think about it before you bring it back to us. And so that kind of sends the hint, not just to Congress, but to the parties that push for this kind of legislation, because they're going to have to really understand that they're entering a risky ballpark. They're going to have, particularly now, given the heightened interest there is in sort of copyright law cases in particular, you're going to see a lot more challenges. You're going to see a lot more people involved in the discussion on the legal front, and frankly on the legislative front. And so you have to think about what strategically you want to get and what you get out of it.
I really agree with that. I think that there are signals from the court that there are lines eventually that Congress would cross. I do think that while it's true that the justices in general say it's not our job to police bad congressional decision-making, you do get the strong sense from Justice Ginsburg's opinion that she thought this was very good congressional decision-making. She thought that it was really important for the United States to come into broad compliance with Byrne. And so I think they were unhesitatingly driven by a felt sense that the statute was a good thing, not a bad thing. We had tried to make use of the line drawing problem, and that is to say, you know, after Eldred, if you can tack on 20 years, and the Supreme Court had said, well, at some point it'll become indefinite and limitless. We don't have to tell you now where that is. We had tried to say that the notion of limited times, meaning that once it's in the public domain, you can only rarely withdraw it from the public domain, gives you a bright line. But I think, there's a combination here of a sense of not wanting to handcuff Congress, and also a confidence in themselves that they will know when the line has been crossed, that they didn't think it was necessary to adopt what we thought was what I think everybody agreed, and Justice Breyer said was a clear rule. But Justice Ginsburg said, you know, the fact that it's a clear rule doesn't make it a constitutionally mandated rule, and so they were not persuaded by that point.
Yeah, and I think also there's this addition of the foreign relations, right? They've got to, you do want to comply with your obligations, Absolutely. And there are consequences for not doing that. And a lot of the amicus briefs dealt with that on both sides,
Yep.
but providing real concrete examples of the fact that if we don't comply, we are impacted in this country in this way or in that country that way. And more, I know in the film business in particular, the international market, in the 90s really became an important vehicle for growth. Mm-hmm. And so if you don't have a relationship with Russia or with China or a vehicle to enforce rights in a meaningful way, you are losing out on an important market because your films are still playing there, but you're not there to compete in any meaningful way because you can't enforce. So, in addition to Congress, they've got to figure out, do we want to get in the executive branch's way of trying to create relationships where it's important for commerce? And these are parts of larger agreements. It's not just an IP agreement. Sometimes they're free trade agreements or what have you, like we're seeing in TPP.
Like so many things, this points up another of our failed arguments. We had tried to frame the case as, look, the copyright clause says we're going to promote, essentially the distribution of works is how we interpret it. But, development of new works, not distribution, but the development of new works and ideas and the progress of science and the arts. And what we had described this as, and I think somewhat accurately, is that a legislative judgment was made that says, look, we are losing overseas IP protection in a number of important countries, in the Far East, in Russia, as a result of them being able to point at us and say, look, what's good for the goose is good for the gander. If you're not going to provide us retrospective protection as you join Berne, then we're not going to give it to you. And that a lot of US intellectual property rights owners had gone to Congress and said, you've got to fix this problem for us because we are losing important markets. And we had pitched our case as essentially a trade had been made, and that is US IP rights holders, copyright holders, were given the potential benefit overseas in exchange for withdrawing the works from the public domain in the United States. And we said that's not a legitimate trade. We said that what the copyright clause is it's intended to give you a right so that you'll create the work in the first place. It is not intended so that you will copyright something and thereby maybe invest further in advertising it, but it won't cause you to generate new works. And there's debate about whether we're right on our on how the economics of the whole thing work. But we had tried to tell this story as it's not really about foreign relations, it's about profits for companies. And I think that the justices, the majority, recognized that that was the legislative judgment that was being made, and they were perfectly comfortable with that. That was the kind of thing that they entrust Congress to do in this space. And it's something that they feel is a proper legislative role.
Well, you're speaking of the legitimacy of the trade, and I just want to ask you for a moment on the practicality of the trade. So as a practical matter, do you think that the URAA really does give the United States leverage over, Russia, for example, to trying to get it to stop piracy of U.S. works?
Well, I'll just speak as somebody who has been on multiple U.S. delegations and negotiations, as part of a team of government officials. And you can be sure that the first thing any country will throw back at us in any kind of negotiation where we're trying to elevate the standards for IP protection or, for exceptions for that matter is, why should we listen to you? You're not even in compliance with, XYZ, Berne, TRIPS, et cetera. So I think that that's actually, it's not theory. It is true that if the U.S. is not, if the U.S. signature on a treaty doesn't mean anything, we're in trouble. So, yeah, I think it's a good faith, clean hands issue.
Yeah, and I also think that, you can debate how strong that enforcement mechanism is because you go through the process and you've got to get enforcement, and a lot of times these things take just years and lots of money to get through. But if you don't have them, that vacuum really takes away your leverage because then you don't even enter the conversation. So it's almost like you actually need it to enter the conversation, and then you want it to be as strong as possible so that you get the enforcement that you need. But you've got to be in the conversation in the first place.
Well, to dissent slightly, our reasonably clear impression, but maybe we were wrong, is that in the wake of our amending the statute to more fully comply with Berne, that several of the principal countries that we were concerned about not providing these rights to U.S. rights holders still didn't provide these rights to U.S. rights holders, Russia being the principal example. But is that wrong? Was there a sea change in people extending these retrospective rights to U.S. rights holders overseas?
So the actual implementation and enforcement question is like a never-ending
No,
issue
I mean just the formal,
US
as a formal matter. Taking Stanley's point that as a practical matter, enforcement is a whole other kettle of fish and it's incredibly complicated. But in terms of the formal overseas legislation that we were hoping to see corresponding, all right, now we lined ourselves up with Berne. Now it's your turn, because you told us in these negotiations, the first thing you would say is you're not in compliance with Berne.
Right.
What happened legislatively? Yeah, my impression is not much, that it was more aspirational than practical.
I want to focus for a couple of minutes on Justice Breyer's dissent.
Yay. Don't limit yourself to a few minutes. Go on and on.
But we need Q&A from the audience, right? So, his premise, his theory seemed to be focused on the incentivization of at least one work and the problems with the majority view with respect to that particular goal. So one question you could ask is whether he would have been more persuasive had he really been focusing on some of the First Amendment challenges. And that, again, brings us back to those traditional contours and how viable those traditional contours really are. So what about that? He folded his First Amendment harm into his copyright analysis should he have taken a different approach? Would that have made a difference? Would it be more persuasive?
Wasn't going to persuade Stanley. I mean, it's very hard to second guess a Supreme Court justice, who all of whom are geniuses, and they're really smart and really funny, for those of you watching. It is, I think, very meaningful. If Justice Breyer, who, having descended in Eldred as well, and is a true believer on our side of the V of these cases, doesn't think there is a independent, serious, freestanding First Amendment problem, then a majority of the Supreme Court isn't. He is, if we have to start from him and build out. If we were going to build out to other people, it likely would have been maybe with Justice Scalia and Justice Thomas on kind of a more historical sense of what the Copyright Clause meant. Justice Breyer, I think you can see in his opinion going on about the Statute of Anne, is kind of trying to talk to them, and a property rights sense that we were trying to create the sense that people who were performing these works in the United States really did have some, vested is a freighted word, but that sense. And also, this was all about Ferners, and who cares what they think? And we got we got no traction whatsoever. The reason that I think that the First Amendment played a role in Golan is we had a hard time explaining some of the statutes that Congress had enacted. It's not surprisingly over the course of a bunch of hundreds of years that Congress would have passed laws that are inconsistent with our kind of pure, semi-pure vision. And we use the First Amendment to say, look, even if the Copyright Clause doesn't categorically preclude you from withdrawing works from the public domain, as did the first copyright law, the First Amendment, there are serious expressive interests that are implicated. You've got to have a really good reason. And what we said is, while the registrar rightly sort of broadly says this is the cost of Berne, what we said is that there are provisions of Berne that would have allowed the United States to make various reservations to it and narrow and provide greater protections for people who were already using the works. The British had done something like that. So we tried to create some flexibility in our position through the First Amendment, making it a little bit more loosey-goosey. Put more on interest on the table expressively, but also say, well, our rule wouldn't be categorical. But there is very little interest in the Supreme Court for that perspective, is I think the bottom line.
And what about Chief Justice Roberts? Because during the oral argument, there was this, intuitive, appeal in the idea of the First Amendment, serious issues being raised, right? But then he joined with the majority opinion in which basically no scrutiny, First Amendment scrutiny, was the order of the day, as opposed to the 10th Circuit, which had even allowed for an intermediate level of scrutiny. Was that a surprise? You didn't mention him as being a possible candidate to be receptive to this. So was his oral argument questioning a surprise, or was the result that actually transpired what you were expecting?
There's just a palpable sense of sadness about all of this. I don't know.
I don't mean to pour salt into it.
But I also don't want to. I'm very interested in what other folks have to say about it.
I wasn't surprised at all. I think there's, for everyone, there's kind of an intuitive appeal to, the poor, pristine public domain, and now we need more things in it, not fewer things. But I guess I object to the premise that they said there's never going to be any First Amendment scrutiny. It's not quite what they said. And as for the dissemination of works versus creation, just to weigh in on that, I was delighted to see them address that squarely. I think it did a great service to the copyright community to have that in the Supreme Court opinion. I think it's fully, I agree 100% with it, and I think that historically speaking, it's very clear that dissemination of creative works was in the forefront of those who created the Copyright Act. Yeah. And in fact, copyright was, statutory copyright required publication early on, so I wasn't surprised by that either.
Yeah, and one of the things, and at least some of the amicus briefs I know the Motion Picture Associations pointed out, was there were also technological advances that could be invested in through dissemination. So, for instance, old films sitting sometimes in the depository of the Library of Congress. Like, you know, those aren't necessarily on DVDs or in any digital format, and they cost money, and they're in the vaults in some of our warehouses as well. Like, to sort of digitize and get them out and recolor and create new opportunities, and then the dissemination, the distribution part on new platforms, that's investment that happens based sometimes on new works, because not as many people are going to want the catalog works as the newer works, but they still have a lot of value beyond profit, just historical value or, you know, film study and the like. And so a lot happens in terms of investment based on knowing that you can do something with it. You know, maybe if the copyright's expired in a work, but you've added something new to it, the new parts are still protected even if the core of the work is in the public domain. And so there are lots of investment opportunities that happen there. Can I ask Tom one question? I don't know if you can answer this or not, but in terms of the strategy you had going in, were you thinking start with Breyer, then work out, or were you thinking this is a principle that 3 or 4 justices you know, might adhere to, and then that might cause some kind of domino effect on some of the other arguments? Like, what was the strategy in the brief writing and oral argument?
Well, the strategy really was one, I think, that involved different arguments for different justices. That there were, you know, if we weren't going to get Justice Breyer, then we were going to lose 8-0, and, you know, we might as well lose 12-0. So there were some people that we were just starting out with. There were, you know, themes that cut across some of the justices' other IP jurisprudence, in the sense of justices who believe that too many IP rights are inhibiting innovation instead of expanding innovation. You see this in a lot of the court's recent patent cases. I mentioned property rights type arguments and historical type arguments. It was in the wake of, it was kind of weird. In the wake of Eldred, it seemed quite clear that we had an uphill climb. On the other hand, they had granted cert in the case, which was a little bit of a puzzle. You know, why there was no circuit split, the statute had not been invalidated as unconstitutional. And so you wondered, why is it that they had stepped into this? And for that reason, there was a big effort to embrace Eldred and say, yes, 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 we love it. You know, it's our favorite case in the world. And all the things that you said in Eldred are not about that Extension Act are not true here, including a lot of stuff about the historical practice. So it was hard for us to see how it is that we were going to get to 5, in the sense that I could walk into any given room of lawyers, and if they were lawyers of the right ideological disposition, looking at copyright law and expression in the way that our clients did, we could get a majority. You know, we could get a majority of them if you agreed with our worldview. But the Supreme Court in Eldred had not agreed with our worldview, right? So the thrust of our position, we already had a majority of the Supreme Court against us, and so it was much more kind of micro-targeting sub-arguments than it was just, sometimes you go into the Supreme Court in cases that I do, and it's like you're home, and, you know, they all love you, and we all agree, and, you know, this is the direction that the law is going in. But we were kind of going against that tide in the court, whereas we were in all of, you know, in lots of academic conferences, we were going to win 9-0. Whereas, you know, with these justices, their just felt sense of this law is very different.
Thanks.
So before we go to the audience Q&A, just one more question for all of the panelists. On the day that Golan was decided, millions of people, along with Google and Wikipedia and proprietors of other websites, joined together in an online protest of SOPA, which is what is a controversial copyright bill meant to provide tougher enforcement measures against piracy. So the protesters were arguing that SOPA amounts to censorship of speech, with websites being blacklisted and shut down with adequate due process. So does Golan have any bearing on this argument and this type of controversy?
I didn't see any connection. It's funny, I think it was maybe with Professor Lee. I was talking outside, and we were talking about, I said, you know, I mentioned something about what academia's impact may have been on SOPA or PIPA and the debates. And he said, actually, we talked amongst ourselves, but we didn't have any impact on the general public, because that was kind of a different debate than we were having here. And I think Golan probably fits into that category where you have this, very arcane, I mean, we're talking about works by foreign authors that, you know, fell out of the domain in a case that, if you went through the procedural history, is, you know, worthy of a gold medal in the gymnastics, you know, competition, because it went up twice, it got reversed and double reversed, and there was a Perrier in there, and then there was a, you know, it was really nuts to get around. And to follow that case, to concern yourself with the foreign authors and to tie that with SOPA and PIPA probably was the furthest thing from the mind of someone blacking out a website. So it's probably more serendipitous from what I could see, and I don't remember the name Golan coming up anywhere that day. But it's an interesting concept, though.
So that was actually Copyright Week, right? So it wasn't just the Wikipedia blackout and the spiraling down of SOPA and PIPA, but it was a Golan decision, and then it was Kim.com, if you recall, getting arrested. So all in the same week. So it was like, you know, Supreme Court, Congress, and law enforcement justice all.
Things come in threes, right?
Right. It was just exhausting that week. I remember it very clearly. So I guess what I would just say what I said before, that we were litigating a law that had been enacted by another Congress in another era before we had a Google or a DMCA, or frankly, you know, at least half, if not more, of the parties who filed amicus briefs in the Golan case. They weren't even around at the time. So the world is very different, and you would just kind of say, well, Congress is saying we need to, I mean, the court is saying, look to Congress, pressure Congress, but Congress is the right place for these to air out. So then you flip to, okay, well, who is Congress today, and what are they looking at? And again, I guess I feel that Congress does have the right parties talking to it, and I think there's no, you know, it's not like those who disagree with copyright owners are shy, right? They don't have any trouble making their opinions known. They don't need a lot of help. So it's a very healthy, if not, you know, stressful legislative process, but I actually think we'd have to conclude it's working.
It would have been really funny if Wikipedia had Shostakovich playing in the background. Then you would have said, oh, I mean, it's all coming together.
Yeah, that's a good point. We have some time for some Q&A from the audience. You have a question back? In the back, to go.
Yes. One of the things that struck me almost immediately about the Golan decision was that Ginsburg's opinion was far broader than it needed to be to reach the results she did. She could, I think, very easily have said, look, we're dealing with forfeitures because of technical irregularities, which the U.S. copyright law by now has obliterated and revoked, and all we're doing is restoring forfeitures. She didn't. She took a much broader position. And this is also a problem I think I've had with some of the arguments that were being made by the plaintiffs, is would this decision have been better, or at least perhaps more palatable to you, had Ginsburg specifically said, we're talking about forfeitures, and any other questions of removal from the public domain will have to wait for the appropriate case?
Well, I think, I do agree that the opinion is quite broad, recognizing that it does say there are going to be limits where Congress can't cross. Nonetheless, there's a footnote that basically says public domain, public domain. You know, there's no, as if that were a First Amendment category. And there are some asides in there that are quite strong. I do think that it was necessary for the court to confront some of the bigger pictures, because while you're right that the statute undid, for example, a situation where a foreign author had not complied with U.S. copyright formalities, and Congress had gotten rid of those formalities when it first joined Berne, nonetheless, there were entire countries whose works we weren't recognizing. And so the statute was undoing some fairly significant work, that Congress had made a conscious decision that, Russian composers, and then there were, a significant body of sound works. And so this wasn't a kind of technical correction act. And that was almost the government's point, in that this was a big deal. We really, Mary Beth Peters had said there were millions of works potentially involved. And the reason that it was important from a foreign relations perspective or from an economic perspective was this wasn't just a few things where people had forgotten to fill out the form and send it in the Library of Congress. There were masses of works that Congress was now going to give copyright protection to, albeit copyright protection that wasn't longer than a US equivalent work.
I would say if the question is, did the court have to really underline that Congress has broad discretion? It did, and I think that the good thing about that is that Congress is dealing with a lot of complex issues with copyright these days, and a lot of them involve international agreements. So I think it's probably not a bad thing for Congress to know that, first of all, it's their job to amend the Copyright Act, and secondly, that going into international waters is a viable reason for them to rethink copyright. And I did say earlier, and I'll say it again, that's the trend. So whether it's an international agreement about exceptions or one about enforcement, the trend is that we have a global economy and we have to work with foreign countries. So I think in some ways the court had Congress's back going forward.
Yes, sir.
As a practical matter, because a lot of artists are using these works that they thought were part of the public domain until the rights were restored, particularly for these foreign works, where does one go in order to find out which works were actually had their copyrights restored? I mean, is there an agency or some sort of clearinghouse for these foreign works?
Well, so the Copyright Office has a database where people filed notices of intent to enforce, right, when the law was first enacted. But in general, we've heard a lot about just clearing the rights and how you go about that. And I appreciate the practical question, and as someone who used to be an in-house lawyer with lots of in-house clients, really wanting the answer always to be that it was fair use or it was in the public domain, and not ever wanting the answer, you need to license this. And whenever when you're an in-house lawyer, and those of you who are, or even if you're at a firm, you know that when a client comes to you and you say you have to license it, they then say, and where do I get the money to do that? And then you say, well, I'm just the lawyer. I don't have your budget. That's kind of a different question, and I think it's a important question, as if we're leaning on institutions that want to do more and more, like let's say the Library of Congress wants to make things available in a way that it never has before, and the answer is that much of that will need to be licensed, not all of it, but much of it. Then the practical question is, well, who's going to pay for the rights clearance? And we don't have a lot of government funds, set aside for rights clearance, but that's the marketplace. And again, Ginsburg, maybe this is another example of where she just kind of took a step forward and said, and I'm also going to address this other issue. She did kind of say, the marketplace is there, go deal with it.
Right, right. But there are two separate questions. One is, okay, you know that a copyright is being asserted. You have the problem of paying the license fee. I had thought the threshold question was, how do you know if a copyright's been asserted? So there's a list, but the true answer, I think, is no, because the statute does not require anyone to notify the government. And this is the orphan works problem. And it's not unique to the Byrne situation. There are orphan works of lots of kinds. But one of the problems is that it is, for all of these Russian works, for example, knowing who the rights holder is and whether they're interested in asserting the copyright and enforcing the copyright the Supreme Court Justice Ginsburg does encourage Congress to enact something to deal with that problem, but says fundamentally it's a legislative problem and there isn't any subsequent legislation doing anything about it, I don't think. So there isn't an easy way of knowing whether the work is presently subject to a copyright that's being enforced.
Right, but the statute also does have this transitional period where if you are using the work, there's a grace period for you to use the work. And then I think you don't even have to stop using the work until you get a notice of some sort, in which case you have an expiration. So for people who were actually using the work, there was some kind of a grace period that might even allow you to continue to exploit it until you got a notice. So I think in that situation, that's one answer. But then for everyone else, there is no list, but you go to where you would go for other works that aren't currently.
But that was people who were using the work
right.
18 years ago.
Right.
For someone who's looking at it now.
But it's no different than the world of copyright, period. I mean, the answer is, where do you go for any rights holder? Between the worlds of public domain and fair use is, licensing. So you have to, we all have to figure that out. And I think that's the pressure on rights holders today, is to come up with efficient, transparent, easy, consumer-friendly ways for to identify owners and license their works, and that's going to have to be part government solution and part private sector.
There was another.
Yes, I had a question. I've heard the phrase vested rights a couple of times, and it didn't seem that in the briefing in the Supreme Court that point, as distinct from the limited times, as distinct from the First Amendment, was put forward. And I wondered if any of the plaintiffs had ever asserted any kind of property type or personalized interest in the activities, the public domain properties that they were using before this law was passed.
Well, there was a taking claim in the case originally that dropped out relatively early in this very long and contorted procedural history. The taking claim really, I don't think, so much was in the work that they were expressing. I don't think that anybody claimed, I now own Prokofiev's Symphony of the whatchamacallit, which is not an actual symphony. But they did create works on the basis of them, derivative works, and they may well have created a well-respected CD. And there was a taking claim that the undoing, that they had a vested property right that was an investment-backed expectation of being able to produce that. They'd spent money making the CD and that sort of thing. And this actually was when Congress first subscribed to Byrne, but didn't include this provision of Byrne. This was the constitutional worry. It was actually the takings concern that motivated Congress to call for a study of the constitutional implications of copyright restoration. But that part of the case, as I mentioned, had been dropped by the plaintiffs before the case got to the Supreme Court. And we tried to kind of interject it back in because there are capital T takings cases at the Supreme Courts, and then there's a kind of felt sense of takings that you can sometimes get the justices to be concerned with, even if there isn't a formal takings claim. But it did not, there wasn't a lot of interest in it, I think because it's very hard for someone who's genuinely interested in property rights as an IP right to say, I, as the person who didn't invent the work, have the property right here, when Congress is trying to assign the property right to the inventor, to the person who created the work. In that competition at the Supreme Court, the creator is always going to win, and won here.
So this has been an excellent discussion. Thank you all for your comments. Tom, you mentioned that part of the strategy was going after Scalia and Thomas. You did end up getting Alito, and Alito asks the first question to the Solicitor General during oral argument, which was basically, can you copyright something that's been in the public domain after an expired copyright? And the SG sort of fumbled his answer a bit. I mean, he said, well, maybe you can't copyright Shakespeare and Ben Jonson because under the copyright clause, maybe they're not authors anymore. And Alito followed up and said, well, I thought Shostakovich and all these other authors were dead too. Do they have to be dead a certain amount of time?
Dead and cold.
Exactly. So I guess I wanted to throw out the question to the entire panel, in light of the court's decision here on this question that they sort of avoided, what's the right answer constitutionally? Can Congress copyright works that have been long in the public domain for any reason at all, basically? They've been in the public domain because of an expired copyright, or they've been in the public domain because Shakespeare has never been copyrighted before. So what's the right answer to that question?
Well, when there were lots of formalities, I don't know the answer to the question, but I think when there were a lot of formalities about having a notice on your work and the like, if you didn't comply with those notices at the time, it was gone. And copyright extension didn't resuscitate that because those formalities were forever gone. So I don't know whether they have the power to do it, but they certainly have never tried to exercise it in that way. This is one of these unique things that, for a number of reasons we discussed, they were willing to negotiate in because there was still a term somewhere. But it seems like at least Congress's instinct has not been to resuscitate works that fell into the public domain well before all these other extensions. So it's the closest I can come. I don't know if you...
Well, it's a philosophical question, and I think it depends on the court, but I think the answer is probably maybe yes, based on Golan. So Golan, what they're saying is we're interpreting limited times, constitutionally speaking, and we have decided that limited times could allow Congress to take things out of the public domain, and we also are noting that it's done it before with the first Copyright Act and a couple of times during wartime where it resuscitated copyrights. So maybe I missed your question, but I think that one can't read the opinion interpreting limited times without concluding that a future Congress could mess a little with the public domain for a defensible reason that doesn't violate the traditional contours of copyright.
Yeah, I think that the answer after Golan is there's a good reason to believe the answer is yes. And because the answer has to be no, I mean, can it really be, what does it mean to have a copyright clause that says Congress can grant copyrights for limited times if that means that Congress can copyright Shakespeare and then continually extend that copyright? If it just has the feel of, then the copyright clause's limitations really don't amount to anything. But I think that it couldn't be more right to say it will depend very much on the composition of the court, and also couldn't be more right to say that there is some brushback pitching going on with Congress in these decisions where it's unlikely that in any broad scale Congress would try such a stunt. Because even the rights holders, I think, would be hesitant to ask for it. And there's not a big Shakespeare's heirs constituency to ask for it anyway, right? There's not a big economic interest, that...
So we're in the public domain now. We've expired, right?
Well, on that note, thank you very much to the panelists for a very stimulating and informative discussion. Thank you.